Writ petition is accordingly allowed.
Publish.
May I please, I recommend item number 13, admission first matter of kindly allow me to move to this petition.
Why?
Already, the party is not willing to continue since this is the case of Lordship LPG dealership.
LPG.
They got settlement and has been running from last 5 years. That's why the
Okay, Mr.
80 Sarkar.
It is Sarkar, learned counsel for the petitioner submits that he has received instructions that to withdraw the writ petition. Mr. S.S. Roy appears for the respondent number 1 and 2.
Lordship.
Anybody else? Huh?
Respondent number 3.
Respondent number 3, out is 1 and 2.
1 and 2.
1 and 2. And who's for 3? Mr. S. S.S. Roy, both of you are same.
Yes.
So one is enough. Okay. On accordingly, on the prayer of the petitioner's counsel, the writ petition is dismissed as withdrawn.
Yeah, please, Your Lordship. Lordship, may I mention item number 12, madam?
Yes.
Here, the petitioner has filed the affidavit in opposition in the stay vacating yesterday, madam. I may be granted 2 weeks for the reply. Madam.
Okay. Written objection has been filed.
Yes, madam. Yesterday.
Interim order may be completed.
Okay, right. Mr.
M. Sahewala.
M. Sayawala appearing for the applicant
Yes, madam.
is granted
2 weeks time, madam.
2 weeks time to file a reply to the written objection filed by the writ petition.
Yes.
This is the matter after 2 weeks, interim order to continue till the next date.
Madam, the date may be fixed, madam. They are enjoying.
Give a date.
May please, Your Lordship. I pray for listing of a matter, my lord, it is listed last on 24th of January, my lord. Any date next week, my lord, that's why you were checking the minutes.
Registry.
Right, Mr. Lordship. Lordship, in item number 23, we have signed an IA yesterday, Your Lordship. Record may be called.
Okay.
Me, please, Your Lordship. I pay for listing a matter, Lordship.
Today. Okay. Provided, wait, madam. Madam, just a minute.
Me, please, Your Lordship.
This court is rising at 1. I don't know if we'll have time. After, because at 2, I've got tribunal is sitting at 2. So, we'll see. Some other date? Next week, okay. Which date? 21st. 21st. 23. What has happened to this? The appeals are still pending or not? You've got no idea.
Some points are not mentioned in the order.
No, there are appeals pending, correct? Appeal is pending before the division bench. What has happened to the division bench appeals? Any idea? No idea. Huh? Pending, so not decided. Okay, next week, 21. No hurry there. Yeah.
Your Lordship, there's an urgency in this matter. It is a contempt case, Lordship. Order has been passed by the Honorable Court on 28/11/2023. But Honorable Court directed to pay amount of 4,62,000. But yet the amount has been not paid.
Is it a new filing or an old filing?
Old back.
You go to the registry.
Lordship, some urgency is required. There, Lordship.
Go to the registry. Yes.
Please, Your Lordship, with the consent of other side, I'd like to mention item number 18, 19, and 20, Your Lordship, of the daily list. Your Lordship, we have to file affidavit in all the 3 matters. So, kindly.
Madam, 18 is infructuous. 18 is infructuous. No. You call your senior. I'm taking up 18. 19 and 20 is okay. 18 is infructuous.
The matter,
What?
the matter will be called for. So,
Yes, I'll call it.
Please, Your Lordship, I request mention for listing of WPC. The matter was mentioned in the last Friday for listing today, but it has not listed despite the law. Apparently, matter will be listed on Friday. Also, there is some urgency.
Okay.
It's with regard to that trolley. According to you, you have got two trolleys. Show me, what is the reason for you saying there are two trolleys?
Good support. Good support. Page. Page. Page 123.
Yes.
It's mentioned मतलब one set.
So because of this, you mean to say it is two trolleys?
Two trolleys.
One
But-
set means
but-
two trolleys.
But they are saying that this is not मतलब the two air compressor because of the next certificate dated 124.
Huh?
They are saying, my lord, that it is only consist of one air
One
compressor.
air compressor.
One-
According to you, one set means two air compressors.
Two.
So you are relying on 123.
123.
And what about 124?
124, it is their interpretation as because, my lord, this self certificate contains only the one chassis number. So therefore, it is only one piece. And our submission is that only the tractor mounted trolley has the chassis number, and these certificates are issued under the Motor Vehicle Act so that it can be registered along with the, when it is attached to the tractor. When tractor is registered, so this is necessary. Matlab, had I not annexed this copy, matlab, this one set would have been sufficient. And because of this, they are saying so. And in reference to that, we have also said that in another tender, similar one set of document invoice has been submitted and they have accepted that.
So this is your case. You are saying that this
Just reiterating paragraph 6 of my affidavit, Lordship,
paragraph 6,
along with paragraph 1 of page 199.
paragraph 6 of
Affidavit.
whose affidavit?
Affidavit filed by the department.
Respondent number?
Respondent number is 2, I think. Yes, Lordship, respondent number 2.
Page?
First one is page 155, that is paragraph 6, Lordship. And second one is, Lordship, page 199. This is the reply to the representation filed by the petitioner. This is dated
Affidavit, page 155, 199.
199.
Just let me see para 6. Further, the cost breakup provided by the petitioner in the clarification dated 5/4/25 is neither, what is this clarification? 5/4/25.
Clarification is 5/4. That is annexure 119. That, no, this is my reply, Lordship. That is their clarification, Lordship.
Well, yes, but where is this?
This is
21.
one 21, 5/4/2025, Lordship.
Page 121.
Yes, sir.
Page 121, which para?
Paragraph,
The one or two?
Paragraph
paragraph
1.
1,
One.
clarification. And also we have mentioned
We have submitted invoice of one set, clearly
One set.
mentioning trolley mounted one set. Where have you,
That invoice mention one set,
just a minute, invoice there 124,
123.
123. It's only says one set. It does not mention.
Well, in quantity. In middle column, middle portion, description of goods. Then third quantity.
One set. One set doesn't have to be two. How can it be two? One set clearly meant trolley mounted or say that was mounted. Two numbers.
In paragraph 6, they said it should have been two sets.
Just a minute. How do you, where do we know that trolley mounted is 35,000 and tractor mounted is 1,30,000?
But this is composite amount has been given. Clarification,
No.
I have given that the amount. If they under the clause, if they would have asked me the separate sale invoices, I could have produced that matter. And they can also verify. Normally, these both trolley mounted and tractor mounted both are sold together.
I don't.
And in page 122, we have also given the reference to the NK Hathi Borua bids.
Tax invoice. Then at page 199 is to censure. You see, the interesting thing is your trolley mounted is supposedly 35,000 and the tractor mounted is 1.6 lakhs, 1.3 lakhs, according to you. Now out here in your invoice, it says trolley mounting air compressor. It doesn't talk about the tractor mounted air compressor. And it gives altogether it gives 165, of course, with the taxes. Now, whenever you buy something, in the invoice, it doesn't use the smaller item, doesn't usually show. If you buy toothpaste, a 250-gram toothpaste and a 10 rupee toothpaste, if they come together, when the bill comes, they don't say that 10-gram wala toothpaste will not be in the invoice. It is usually the bigger thing that is in the invoice. How come out here there is only the trolley mounted air compressor is there in the invoice?
Because they issue.
Page 123.
Because as per practice, they issue the sale certificate.
But then they're talking about trolley mounted air compressor.
The sale certificate, but it is tractor mounted.
No, come to page 123.
Yes, madam, this is trolley mounted. So the sale invoice has been enclosed at 124 to show that it also includes this tractor mounted. This could have been clarified had they exercised their clause by which they can seek any clarification. And when this similar set, one set is considered as a sufficient, they should have considered in that manner. Now in the reply in paragraph 6, they said,
No, just because they have accepted one doesn't mean they have got to accept yours also. But yes, there is one thing, Mr. Nayak, you could have verified whether he had two compressors or not.
Not my submission will be, it would have been the only reason for rejecting his technical bid, Lordship. Further verification could have been opted for. But in this case, Lordship, there are other grounds also, and the second ground is most important.
What is the second ground?
Lordship, second ground, Lordship, he failed to mention the work in which he was declared as L1.
No, but then what does the NIT require? He has to be the winner.
Winner.
Let us see the winner.
Winner in which LOA has not yet been issued.
Winner in which LOA has not been issued. So,
In his case, same case, Lordship. He is the L1 Lordship.
but you see, but winner means what? Winner means that he will be issued LOA. Correct. But has not been issued LOA. Now, the thing is that his abnormally low rate, you had asked for a clarification.
Yes.
Now he had submitted his justification, not clarification, justification for the low rates. Did you take any decision prior to completion of prior to the last date of submission of the bids? Not you, with regard to the other case, as to whether his justification had been accepted.
Lordship, justification only with regard to his price bid, Lordship.
Correct.
His quoting.
Correct.
So far as his L1 status, Lordship, that will still remain.
But can you say L1 means to be a winner?
Yes, Lordship.
Let
Lordship,
us see that.
kindly
Let us see that
Page-
NIT.
Page 48, Lordship.
Page 48.
That is the clause, Lordship.
Page 48. Yes.
Page 48 starts from page 47, Lordship.
Yes, but-
4.2.
Yes, but
I am at page 48.
yes.
B, Lordship.
B. Yes.
Value
Yes.
updated to the price level of the year indicated in the table number 3 below of existing commitments. Lordship, this B value minus his this is decreases his bid capacity, Lordship. That is why he has not shown it. Works for which the bidder has emerged as the winner of the bid or ongoing works to be completed during the period of completion of the work for which bid is invalid. For the sake of clarification, it is mentioned that works for which bidder has emerged as the winner of the bid, but LOA has not yet been issued as on the day before the opening of the financial bid shall also be considered while calculating value bid. So this is, in my understanding, Lordship, clear enough.
No, but then you see, the thing is that does the authority who has asked for justification for the low bid, does he have the option to either accept the justification or reject the justification, or does he have to accept?
But Lordship will kindly appreciate, Lordship, till the date of opening of the bid, his status as L1 has not been questioned, Lordship. Only justification has been sought for. It was not decided. Still, he is L1 on the date of opening of the bid. So that has not been changed. LOA has been issued subsequently. That is another issue, Lordship. But this clarification portion, Lordship. Even if LOA has not been issued, still on the date of opening of the tender, you are L1 and it is the status in the uploaded
You
technical.
see, the problem is this B value, this B, doesn't speak of L1. It only speaks of winner.
Yes.
It doesn't speak whether you're L1 or H1 or
That in
it only
that
speaks
case,
of
Lordship,
winner.
that in this clarification will come into play, Lordship. Clarification says prior to issuance of LOA. Prior to issuance of LOA, Lordship, L1 means who is at the top of the.
No, please don't use the word L1. It has not used the word
Winner.
L1 anywhere. It has used the word only winner.
Lordship, in this case, L1 is the winner. If you are L1, then you are winner.
But then that L1 is again subject to justification.
Lordship, justification for the purpose of imposition of additional performance guarantee.
But that is not mentioned here, no?
clause 30, my lord, clearly says, my lord,
Clause
employers
30.
right to accept any bid and to reject any or all bids.
Page
Page 70,
1.
only 70. Lordship may come to. clause 29.1. That is the normal procedure, my lord. Subject to clause 31, the employer will award the contract to the bidder whose bid has been determined to be substantially responsive according to the bidding document and who has offered the lowest evaluated bid price. The value of bid price shall be inclusive of all amount of emergency work, etc. Then clause 30. Employer's right to accept any bid and reject any or all bids. 30.1, notwithstanding clause 29, the employer reserves the right to accept or reject any bid and to cancel the bidding process and reject all bids at any time prior to the award of the contract without thereby incurring any liability, etc., etc. So unless the
No,
justification
that is
is
the,
accepted,
yeah, no,
they
no,
have a right.
that's only one thing. In this NIT, is there any definition given to the word winner? Is there any definition or explanation as to what do you mean by winner?
Winner has not been given, Lordship, but if Lordship comes to page 70 itself, Lordship.
70, yes,
Lordship may kindly say 29.2.
29.2, yes.
The bidder shall be declared as the selected bidder
The bidder,
in pursuance of to the procedure defined thereunder, Lordship.
uh,
Here, Lordship, L1 is mentioned.
bidder is different. Bidder, everyone is bidder.
That has to
I
be
want to
read.
know the winner, why, why, that you have used the word winner
Lordship,
only in one place.
Lordship, in my understanding, Lordship, that it should be left to the understanding and wisdom of the tendering authority, Lordship, as
Where have you said that in your affidavit?
Lordship. This winner,
That winner means L1?
that third winner has not been interpreted, Lordship, or
No, it
explained,
has to,
Lordship.
then how do I know? The authorities have to interpret that.
Then Lordship.
See,
it comes
according to your submission,
Yes,
if I am to accept the authorities' definition, show me the definition given by the winner, the interpretation. given.
Paragraph 8, Lordship,
Paragraph 8, page?
page 156.
Yes,
Lordship, I'm coming to the next bit. So first part I'm skipping.
yes, yes,
Second page 157.
yes,
Lordship, may kindly start from the fifth line, Lordship.
yes,
Starting with the word the bid towards the
Yes.
right hand side. The bid due date of the instant work was 18/2/2025. Hence, the petitioner has received intimation of L1 status for job number so and so, in view of which bidder's request has not been accepted. This is the clarification given, Lord. As the petitioner has not shown the said work in B value of his bid. And for this purpose only, Lordship, one judgment was placed on last date, Lordship, by my learned senior colleague, Lordship.
what was that?
Therein also same issue involved, Lordship. In that case also, Lordship, the
Uh,
petitioner,
which case was this WA?
yes, one WA is.
Yes, which para?
Lordship, initially in that case, learned single judge has allowed the case of the petitioner, but subsequently the division bench interfered with.
So where is the relevant portion?
Right here, the winner one has not been, here in regard to calculation of the bids, the court has interfered, because why these works are not being shown by the candidate, because it will increase their bid capacity. If they show this work, then it will decrease their bid capacity. So the court has given an elaborate, assessment of.
What do you mean decrease their bid capacity? What do you mean? Example?
They.
That is existing commitment.
That they require to have a certain value of work to qualify themselves as a successful bidder. If they show this work, then their bid capacity will go down.
How will it go down?
Lordship,
Yes.
one way of calculating bid capacity is your
expect the bid
existing
capacity.
commitment, Lordship. If your existing commitment is more, then your bid capacity is less. That is B value.
Okay, that way, okay.
Page 40.
Because his money will be stretched thin.
Yes, Lord.
Page
There is more in.
Anyway, but then the definition of.
47.
Well, I have bid capacities over 3,000 crores. And this, even if that work is reduced, I have given in my affidavit in reply.
Anyway, that is not the issue I'm going into. I'm only going into the issue of this winner. Whether L1, whose justification has not been accepted or rejected, can be said to be a winner.
And there is also another ground also that is, it has to be required in the prescribed format.
Correct?
Admittedly, that is not in the prescribed.
No, but then his case was that subcontract work of the subcontract work that has been completed. You see, the work has been allotted to the principal contractor, not to the subcontractor. So the principal now, when you look at when you look at his thing, his case, his subcontract work had been completed, and this has been reflected in another case of this High Court, in another order.
That case again was not raised. Finally, it was not.
No, 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 no.
Fractures.
No, but the issue of him having completed his subcontract work is not disputed by anybody. And that has been reflected by this court in another case.
But I think that did not result in final judgment. It was only.
No. That is a different thing. That issue is different. That issue is whether his subcontract work could be used as his experience for while applying for another contract work. So that was the issue there. And it was reflected there that he had completed the subcontract work. And as such, now his case is that since I finished my subcontract work, there's no requirement for me to put this uncompleted contract work, which has not been completed by the principal contractor, to be included in Annexure 8.
But my understanding is that, with utmost respect, this is the area where they are the best people to judge it. I will not.
No. Sorry.
Because
Sorry, you have not read the order of this court or the
I
the
have seen-
certificate issued by the Arunachal PWD. Did
not
they,
because I have seen-
whether if you want to say that the Arunachal PWD is wrong and the order passed by this court is wrong, then that's a different.
But that
So
is
if you cannot, that is
That is not-
a settled position.
If I can get the reference of the number, because one case they have referred, I have seen the final order, in the final order, it has become in practice. So I'm not relying.
No,
on
that
it
is a
to
different thing.
change order.
That is with regard to his experience. His case was his subcontract work should be included as a part of his past experience while applying for another contract. You look at here, it's here. The judgment is here in this case. It's here. You have not looked into it.
That one judgment.
Anyway, that is a different issue. I'm not going into that. I'm only going to two issues. What is the definition of winner? And number two, whether he had two air compressors or not. Now, so that I wanted the clarification as to how he has found that if he's come to the conclusion that he has two air compressors. So that I will go into. I wanted a clarification. Clarification is not there fully, but I'll have to try and make out what can come out of it. And with regard to the winner, that winner, what does it mean? Can you, a
My-
person who's justification, no, supposing, a winner for me, a winner is a winner. You cannot take away that name of winner to a person. So what happens? He's L1. He have asked for justification with regard to his abnormally low rates. Now supposing his justification is not accepted by you, then can he be said to be a winner?
If
Now,
his
forget this case, forget this case.
If his justification is not accepted, the LOA will be issued to somebody else. Then he will approach this honorable court by stating that in spite of being
He
L1.
might not approach.
No, Lordship, that is my understanding. He will approach citing the only ground that in spite of being L1, I have not been granted the LOA, indicating therein, Lordship, I was L1, I was the winner. In spite of that, I was not given the contract.
The issue is that if he's a winner, it says that a winner, but who has not been given the LOA as on date. So what basically the tender condition appears to show is that he is a winner, but as on date, he has not still been given the LOA. That the LOA is just a matter of time. It has not come in the meantime. That's all it appears to me. And let's see.
So that may be one way of interpreting.
Yes, either way, let me see.
Understood it in their own way. Lordship, once again, Lordship, I'm into that context, Lordship, referring that Silpi construction judgment, Lordship. They being the author of the tender, Lordship. They interpreted that clauses are in their.
Shilpi construction, have we mentioned?
Yes,
Huh?
Lordship, last week I referred.
No, I just, yes, it's mentioned.
Lordship, so
I
far
have,
as-
I've made it partly, I just
so
wanted
far
to
as
clarify.
This case is concerned, Lordship, this is WA 36 of 2020.
But 36 does not have any relevance here.
Just, Lordship, just one paragraph or two paragraph, Lordship. would
Yes,
like to
yes.
see. Lordship, in this case, the petitioner's justification was that what he was earlier a proprietorship firm, subsequently it was converted to a company, Lordship. And the contract that was in which he was L1 as proprietor was not shown in the bid which was submitted by the company, Lordship. And initially, Learned Single just interfered with the decision of the department, Lordship. But subsequently, court said no.
Okay. But was the petitioner in the other case, was he a principal contractor or a subcontractor?
He is the principal contractor, Lordship. But
Out here, he was a
that's a
subcontractor.
ground two, Lordship, I'm saying. In that case also, Lordship,
Winner
he was
regarding.
also the L1, Lordship, but no LOA was.
Was he asked for justification of his low rates in the other case?
That aspect.
That is the problem in this case. There is a justification has been asked for by you. And that justification, if you can say that justifications have to be admitted and have to be accepted, then I understand that he's a winner in all respects. But if the justification can be rejected by you, I do not know if you can say that he's the winner. That is the only issue. Because you see, please bear in mind, if I pass an order here, as per your interpretation, then in another future case that might happen, they'll say that no, once he's L1, he's a winner.
Yes.
And winner means winner for all things. There's no question of now going back and saying that your low rates cannot be accepted. As long as you provide any justification, that's enough. We have to accept.
Lordship,
You
one-
have got
one
to look
more
at that
reason- one
aspect
more
of it.
reason for what I'm submitting, Lordship. These days, Lordship, just because my quote is 10%, 20%, 30% below, generally we do not reject their claim, Lordship. We reject their peak, Lordship. Generally, what we do, we call for justification and then.
If you find that it is
Additional
yeah.
performance guarantee.
correct, I understand, but then
Generally, because of low price bid, Lordship, these days we do not
No.
reject any tender.
you might not even want to accept his bid even after justification, which you're entitled to do. That is what I'm trying to say. That if you have got the right to reject his justification, that nowhere makes him a winner, because that winner tag is conditional to you accepting his justification. A winner is declared after everything is said and done. In your case, everything is not said and done. The justification has still to be done.
Yes.
It has to still be accepted. Then only you can say, yes, you're the winner. I've never heard of a person running 100 in a 100-meter dash, completing 90 meters, and then you're asked, the organizer tell him to stop. Now please explain how you're going to go, at what speed you're going to go for this last 10 meters. And then say, till we take a decision, we accept him to be the winner. That's not he has to complete the race.
Yes, sir. Definitely, that may be one way of interpreting. Also.
Yeah.
My understanding will remain till the LOA is issued, he remains the winner of the contract. It may
Okay.
change after issuing it to somebody else.
Okay, let me think about it.
Where the clause 30 comes.
Let me see. Put it back to my table. Let's see. Order inside.
The matter pertains to non-payment of contractual dues.
Yes,
Is
Mr.
admitted.
Barwa.
Last occasion, Lordship, we sought time from the
Yes.
Political Department.
And what are you going to ask today for time?
Time, they sought some time.
Lordship,
Yes.
the only contention is that the additional deputy commissioner has filed his affidavit, your lordship, admitting the dues.
They have said that we have sought for the funds from the Home and Political Department and the funds are not released. The
I don't have the affidavit.
affidavit is there.
Okay, affidavit will be.
In the last page, page 39, your lordship, they have annexed a letter.
Is finance department a party here?
Yes, your lordship. One,
So this is for what? Higher charges?
hiring charges and also supply. charges.
Supplies.
Right. So this, there are three contractors in this letter, your lordship. So they have sought total of 2 crore 15 lakhs of amount in the year 2023, your lordship.
Why is this? There are three lead petitioners.
No, lordship. Here,
Huh?
I am for only one of them, your lordship.
Here for which
AB,
one?
AB Enterprise, number one, your lordship.
AB Enterprise.
AB Enterprise.
They sought the fund from, in one head to the government.
Maybe, but you have admitted to the amount, then you pay.
Yes, yes, but from the instruction lordship, they have sought some, documents from the office of the district commissioner lordship,
Who has sought?
the government lordship.
Then have you given the documents?
That instruction I don't have.
Why? Joint Secretary, Home Department.
Yes.
Okay, right. The petitioner's case is that he has not been paid his bills for supplies amounting to rupees 90,63,697. Full stop. In terms of para 3 of the affidavit filed by the District Commissioner Kokraja, bracket respondent number 4. The petitioner, there is an admission that the petitioner is to be paid rupees 90,63,697. And that the proposal for payment of the same has been made by the office of the respondent number 4 to the Joint Secretary to the Government of Assam Home and Political Department, white letter dated 25/7/2023. Next para. Mr. S.R. Barwa, the learned counsel for the respondent number
1, 4 and 5.
1, 4 and 5 submits that the Joint Secretary to the Government of Assam Home and Political Department has written a letter dated 9/5/2025 to Miss Udas, Additional Senior Government Advocate, Assam, informing her that certain documents have been sought for from the DC Kokraja in connection with the payment of the outstanding bills of the petitioner. Full stop. As and when the requisite documents from the DC Kokraja are furnished, further action would be initiated for payment of the admissible amount from the available budget. Full stop. Next para. Mr. S.R. Barwa shall produce the letter issued by the office of the DC Kokraja seeking certain documents from the DC Kokraja as reflected in the letter dated 9/5/2025. The Mr. S.R. Barwa shall also produce shall produce the letter that may have been made with regard to the information sought for by the Joint Secretary to the Government of Assam Home and Political Department. The letter dated 9/5/2025 issued by the Joint Secretary to the Government of Assam Home and Political Department is made a part of the record and marked as Annexure X. List the matter on next week.
2 weeks lordship, because from DC Kokraja.
Okay, give a date. List the matter on so and so, on which date Mr. S.R. Barwa shall produce the letter issued by the Joint Secretary to the Government of Assam Home and Political Department seeking the required documents. Seeking documents from the DC Kokraja. You bring those that letter. Otherwise, we're going to call up your thing. What is this? 23, the thing has been done. It is- Right. Right, Mr. And half learned counsel for the petitioner who submits that the respondent has not made a verification for payment of the dues payable to the petitioner in terms of the order dated 10/5/24 passed in WPC 2382 of 24 and the order dated 7/6/24 passed in IAC 1621/24. Issue notice returnable in 4 weeks. Petitioner will take steps within 2 days. List the matter after 4 weeks. Heard Mr. N. Hoppler, counsel for the petitioner, submits that the respondents have not verified the dues payable to the petitioner in terms of the order dated 29/5/24 passed in WPC 697/24. Same thing, huh? Step within 2 days.
Yeah, present. In this case, Lordship, the
Is this a bench 5 matter?
Lordship.
Is it a bench 5 matter or what? No.
No, that, no, that.
Okay, what is to be done out here? Now, the petitioner entered into agreement.
No, Lordship, here in this case, the page number 25 annexure 5. The representation that was submitted for the commissioner, GMC,
Ah,
that has not been acted upon, Lordship. There is no action on the part of the GMC authority.
what is your, what is, how are you, how is your right
You have said that,
affected?
Lordship, I am the owner of the property. What
You're
has
the owner of the
happened-
property, okay.
What has happened, I've given it this power of attorney and the agreement was there with the builder.
Ah.
Now the builder has made a construction in the 4th floor without any permission, without.
So your agreement was till which floor?
Up to 2nd and the 3rd floor.
3rd floor?
Yes, but he has made the construction in the 4th floor.
Fourth
Everything is
floor.
there in the representation also, Lordship.
Okay.
That's the reason I submitted the
Now
representation.
take the inspection, my lord, that initially the NOC is up to 2nd floor, and then he regularized the 3rd floor. Now allegation is the 4th floor is they have constructed.
So you take a decision on this,
Yes, yes.
we'll dispose it off. No, you
Yes.
take a decision on this by speaking order.
In the meantime, if he obtains instruction, on the next day, it takes, it can be disposed of.
Ultimately, we have to take action.
No.
You have to, yeah, ultimately, you see,
No.
by the time he obtained instruction, 6 months will go. By the time he obtained instruction, I mean, a few months will go.
Then a time frame may be given.
Time frame, you decide this.
It's not, that is, page 25.
Yes, right. Heard Mr. S.P. Chaudhary, learned counsel for the petitioners, who submits that the petitioners entered into an agreement with the builder, that is respondent number 6, for developing the petitioner's land. The agreement provided that the builder would construct a building
Up to G+2.
up to construct a building being G+2. However, the petitioner, the respondent number 6 has now started construction beyond the 3rd floor without the permission of the petitioners and the GMC. He submits that despite the petitioner having submitted a representation dated 20/3/2025 to the commissioner GMC, the GMC commissioner has not taken a decision on the same till date. He accordingly prays that a direction be issued to the GMC commissioner to take a decision on the petitioner's representation within a specified time period. Mr. S. Bora appearing for
Respondent number 4 and 5.
4 and 5. Anybody else?
Lordship, I'll be appearing for respondent number 2 and 3. R. Talukdar.
4 and 5
One.
and Mr.
One, two, and 3. Lordship, 1, 2, and 3. R. Talukdar. appearing for-
Mr. R. Talukdar appearing for
Respondent numbers 1, 2, and 3.
1, 2 and 3 and Mr. S. Bora appearing for respondent number 4 and 5. Submit that they do not have any objection to the prayer made by the petitioner's counsel. Next part. In view of the consent of the parties, this writ petition is disposed of with a direction to the commissioner GMC to take a decision on the petitioner's representation dated 20/03/2025 within a period of
2 weeks, Lord. 1 month.
1 month from the date of receipt of a certified copy of this order, along with a copy of the writ petition. Full stop. The Commissioner, GMC, bracket, respondent number 4, shall give an opportunity of hearing to the respondent number 6 prior to taking a decision on the petitioner's representation dated 20/03/2025.
All right. May I please, Lord? Should the matter pertains to allotment of contractual work by municipal authorities. The NIT at phase 19, Lord. 91.
Yes,
Their Lordship, then they invited for earthwork, and so I, along with the private respondent, altogether 4 bidders participated in.
all of y'all were same bid amount.
All quoted same bid amount.
Then,
All quoted same bid amounts. Lordship will find the
so work order issued to the respondent number 6.
all quoted issue to the respondent numbers.
So what is your ground of challenge?
My ground of challenge, Lordship, will kindly on to page 21, Lordship. The bidding document,
Yes,
bidding document, Lordship, page 22, Lordship.
yes,
The qualification of bidders.
yes,
The Lordship will find the F, the Fs. The Fs.
yes, F to F, yes,
Annual turnover. Lordship.
yes.
Annual turnover 2023 to 24 has
So
not.
your turnover is more.
My turnover is more, and my turnover is as per the requirement of the NIT. And the private respondent is not fulfilled the requirement of the NIT. As
He's
per
not
the-
fulfilled 2F.
F, Lordship.
He's not fulfilled 2F. And which one?
And Lordship.
And also J2J
And J. He has not fulfilled the J.
and 2K.
And K, Lordship. Has not fulfilled the K. And
That's
Lordship-
all?
And Lordship. Interestingly, last on page 24, my Lordship, page 24. M.
Yes, yes.
Lordship. Bidders value below 10% of the package value shall not be considered. Here, Lordship, the price quoted by all the bidders, Lordship, is below 10%.
So all of you should not be considered then. It cannot be only you.
That is.
Huh?
So there is, my submission is that, Lordship,
It should not be given to anybody.
it should not be given to. And they have chosen the private respondent without assigning any reason. No, all the.
Okay, we'll issue notice then. We'll issue notice. Anyway, right, heard, mister?
Yes.
Huh?
Yes.
A Islam Learned Council for the petitioner who submits that the petitioner participated in the NIT dated 25/2/2025 in respect of the contract work. Earth filling, so page 19, somewhere in red up. Okay. The petitioner's council submits that all the four bidders had submitted the same bid amount for the contract work. However, the respondent number 6 was allotted the work order without the respondents giving any reasons for the same. Full stop. He submits that the petitioner's bid he submits that the bid of the respondent number 6 was in violation of clause 2.2 bracket F,
J,
comma 2 bracket J and 2 bracket K of the NIT,
bidding document.
of the bidding document, And as such, the respondent number 6 could not have been allotted the work order. He also submits that the bids of all the tenderers was in violation of clause 3 bracket M, small m, of the bidding document, as all the bidders had submitted bids below 10% of the package value. As such, a fresh NIT should have been issued by the respondent. Issue notice returnable in 4 weeks. Mr.
Yes, sir.
SF notice on behalf of
Respondent number 1, 2, and 3.
1, 2, and 3. What about 4?
No, Lordship.
Dubri Municipal Board? No, it have to go to them.
Yes.
Petitioner takes steps for service of notice upon the, what about Executive Officer, Dubri Municipal Board?
That they will, they are separate company.
Okay. No standing council?
No.
Okay, petitioner takes steps for service of notice upon the respondents number 4 to 7 by registered post with AD within 3 days. List the matter on. Huh? After forgive a date.
I have interim prayer, Lordship.
When you yourself are not eligible, according to your own submission. This is the question of interim. 23rd June. Okay. That's right. The issuance of the work order shall be subject to the outcome of the writ petition.
Wait, this one. The petition is a small fee, Goa, my lord. Initially,
I think this is a bench 5 matter, madam. This is a bench 5 matter. Item 6, no?
yes, ma'am.
Bench 5 matter. Enhancement of lease rent
Yes, ma'am.
and eviction notice. This is not a bench 4 matter, bench 5 matter. Okay, right. A registry to verify and list it before the appropriate bench, comma, which appears to be bench 5. Huh?
Right.
This also appears to be a bench 5 matter.
It will come big next Monday, Lordship.
Let it go before bench 5.
Let the rest be verified.
Yes. Because yesterday I had called them. I had the 6 and 7. I said, how is it before bench 4? So let them verify. Registry to verify and list it before the appropriate bench, in as much as it appears that the said matter relates to bench 5.
Can it be on Friday, madam? Some urgency.
I don't depends upon you. When do you want?
Friday. Friday, no problem. He is sticking to what he is saying today.
Okay, this is the matter of Friday.
Highly obliged.
So we'll issue notice, that's all.
Or my, like, as per section 14, the licensing authority is bound to give a reason order. He has not passed any order as of today. What happens?
He has not passed any order?
Not
The-
order. He realized he was sitting over a report of the SP. That report under section 14 is also not maintained.
Then I'll obtain instruction whether order was passed or not.
Right.
That will be better, Lord.
Okay, right. Heard Mr. B. Kaushik, learned counsel for the petitioner who submits that the petitioner's application for an arms license has not been recommended by the SP Kolagat. Even though section 14
Of the arms.
of the Arms Act, what does it say? Tell me.
Section 13 says about grant of license, section 14 refusal. If there is a refusal, then you'll have to cite reasons for refusal.
But this is only a recommendation. That is by the authority.
That is by the authority.
Then-
Licensing authority has not
then-
refused it.
Then,
When I asked for the status of my license, the application, the
So you are
SP's
only-
recommendation was given to me.
you are only apprehensive.
No. On the ground of, they have verbally said me that it is refused. And along with that refusal, I asked for the refusal order, the SP's recommendation is given. And that SP's recommendation, on the face of it, my lord, are perverse because the documents which are annexed with the application has not been taken into consideration.
What have I said? And no, and as such, apparently rejected by the district commissioner.
No, that cannot, we cannot say like that because I don't know the.
Not you, he.
Yes, Sami Sama.
He can say anything. Correct, that's what you're saying.
is sitting over the recommendation, not passing any order of regarding
Acha,
grant
SP
or refusal.
so who, acha, but you said that the SP has not recommended.
SP has not recommended.
Who is the final authority to
Licensing
issue?
authority is deputy commissioner.
That's what I'm saying. And it has been apparently rejected by the deputy commissioner or not? You don't know.
No, we
No,
don't.
for the, what have I said? Has been not recommended by the SP Golaghat and no, SP Golaghat, full stop, he submits that the licensing authority is the district commission who has not taken a decision on the petition's application. Mr. S.R. Barwa submits that he will obtain instructions as to whether any decision has been taken on the petition's application for grant of a arms license. In terms of section 14,
13 and 14.
13 and 14 of the Arms Act 1959. We issue notice or we,
Instruction lordship.
okay, list the matter on when.
Wait. Wait.
Lordship of kindly pass forward the letter for the time. Mr. P. Sharma is appearing.
Who?
Mr. P. Sharma. P. Sharma.
Lordship, at this stage, I'm already asking for notice and let them take instruction, Lordship. And let the matter come, there is one.
No, your only issue is that the decision has not been taken
Yes.
with regard to the NIT. That's all. So you obtain instructions whether the decision has been taken or not. That's all. Or does he have the answer? What? You don't know.
We have to take instruction.
Okay, right. Heard Mr. B. Chakravarti, Learned Counsel for the petitioner who submits that the respondent authorities have not taken a decision for settlement of the Kakra Nadia fishery in person to the NIT dated 8/11/2023. In the meantime, some miscreants are catching the fish from the fishery. Mr. Huh? R. Chetri, appearing on behalf of Mr. P. Sharma for the fishery department is granted how much time?
2 weeks.
Is granted 2 weeks time to obtain instructions as to why the fishery has not been settled pursuant to the NIT dated 8/11/23. This is the matter after 2 weeks. We'll issue notice. Heard, Mr. S.K. Sinha, Learned Counsel for the petitioner, who submits that the petitioner's vehicle hire charges amounting to 1,52,74,203 has not been paid. Issue notice returnable in 4 weeks. Mr.
R. Talukdar.
R. Talukdar for
Appearing for all respondents but for two.
appeals for all, except notice of all respondents except respondent number 2. Who is for respondent number 2?
Finance Department, Lordship.
Ms. R.M. Barwa is not here. Yeah, Mr. P. Nayak, accept notice on behalf of respondent number 2. List the matter after 4 weeks to enable the response to obtain instructions and file affidavit.
In this case, Lordship, I was evaluated as a L1 bidder in queue of Lordship issued by the block development. But if that Lordship, no decision has been given, no.
They will take time and
Let them take instruction.
Next step, right? What is the status of?
okay, right. Mr. P.P. Dutta, Learned Counsel for the petitioner submits that the petitioner applied for 3 contract works pursuant to the NIT dated 7/2/2025. Though the petitioner was declared L1 in all the three contract works, no work order has been issued to the petitioner till date. Mr. P. Nayak, Learned Counsel for the PWD, submits that, for the BTC, submits that he will obtain instructions within a week.
Not sir.
This is the matter.
As regard the status of the bill.
This is the matter on
Objection.
My lord, I click for a passover of the first time.
Yes.
So in this method, once order was there, directing the authorities to take a decision on the application submitted by them. My instruction is that authority has not taken any decision.
That's the only thing there.
But I'm submitting lordship will run me 1 week term or 10 days time. Lordship in the meantime, they will issue.
You take a decision because I think basically now this has become, yeah, in a way, it becomes like, so you just have to take a decision. Either way. We'll listen next week, 22nd.
Direction can be granted 10 days time for them to have and give a report, lordship, compliance report. That can also be done, lordship.
Okay, we'll we'll give you 2 weeks then, or 3 weeks time. Let them take a decision.
Disposable.
How does it matter? Yes, because at the end of the day, he'll have to challenge that order anyway, if he wants. If there is something to challenge. There might not be anything to challenge.
Nothing is there.
Huh?
In fact, not until December 2024, he was the administrator of the government.
It appears that this is therefore, I don't know why he has filed. There must be some reason which I don't
No,
know.
lordship, that thing, only thing is that we wanted to know so that we can go forward, at least go forward.
Okay, right. Right, Mr.
P. Decca.
P. Decca, learned counsel for the petitioner who submits. That the order dated 10/5/2023 passed in WPC 2340 of 2023 had directed the respondent number 3. Respondent number 3 therein is same here also.
Same here.
Direct respondent number 3 to examine and take a decision on the petitioner's representation dated 8/4/2023 within 1 month. Wherein the petitioner's bid amount was found to be the highest in respect of the auction held for the Fatemabad Tea Garden. Next para, the petitioner's counsel submits that the non-compliance with the order dated 10/5/2023 passed in WPC 2340 of 2023 was not taken up by filing a contempt petition as the same was barred by limitation under section 20 of the Contempt of Courts Act. There. He accordingly submits that a similar direction may be issued to the respondent authorities to decide the petitioner's representation. Mr. P. Nayak submits that he has got no objection to the prayer made by the petitioner's counsel. Next, in view of the consent of the parties, the respondent number 3 is directed to take a decision on the petitioner's representation dated 8/4/2023 within a period of 3 weeks from the date of receipt of a copy of this order. The writ petition is accordingly disposed.
And a compliance report will be submitted to this, to the registry of this court.
A compliance report should be submitted.
Instead, lordship, I furnish.
Yeah,
I will furnish a copy.
yes, the decision taken should be furnished to the petitioner.
And the registry of this honorable court.
No, to the petitioner.
It is done.
Okay, to the petitioner and the registry of this court.
I don't know what is his intention.
I don't know.
If the petitioner is sufficient, lordship.
Oh, why don't you give it to him?
That is what I'm
The
saying.
council.
Not if the authority will furnish a copy to the applicant, lordship.
Oh, why don't you furnish a copy to him?
Personally to him.
Yes.
Yes, possible, lordship.
The decision taken by the respondent number 3 shall be furnished by Mr. P. Nayak, Senate counsel for the respondents to Mr.
P. Decca.
P. Decca. That's what. Learned counsel for the petitioner.
Your lordship, today, I'm in press for interim order
but I'll just place your lordship here, but 3 days back, I took permission from the court to withdraw with the liberty to refile it because of the subsequent events. I'll just tell your lordship, this was NIT, which was quoted, why I sought for to refile it. This is the NIT which was quoted by ONC for hiring of scrapping wages into a state, one is Assam and one is Ahmedabad. We were concerned only on Assam, 24 units. These are my highly technically skilled work where my note, the rig has to be clean normally. And for this, these units were required.
Oil rigs.
Rigs.
Oil rigs.
Yes, this is clean, basically for that purpose. Now, my lord, there was a few dates which was given by the authority, the closing date. But they have extended it, by way of corrigendum, they have extended it. And the last date of submission was 1/8/2024. Now, 1/8 to the techno-commercial bid, you have to qualify. Once you qualify, then the financial bid. 3/1/2025 was the date where techno-commercial bid opened at 4:15 PM. Techno-commercial bid, and thereafter 4:30 they opened the financial bid, where the private respondent was qualified, respondent number 5 qualified. Now, on 14th of January 2025, there was an email which was sent to the party concerned that NOA has been issued to the private respondent number 5. Now, this was put to challenge by us on 12th of February 2025 by a writ petition before the Honorable Court. The matter was heard by the Honorable Court and there was an interim order which was passed saying the Assam and Ahmedabad both here at this state. Now, the ONC came up before this court by filing an application modification variation of the order somewhere on 14th of March 2025. And the writ petition which was moved on 12th of February 2025. Now, their whole contention of vacating of the order was that, look here, there is an NOA which has been issued on 14th. You moved the matter on 12th of February 2025. Their contention is that there is a suppression of material fact before the learned single judge in the writ petition. That already an NOA has been issued and you said the work order has not been. This is the basic contention, which they move for modification variation of the order. Now, they annexed that the NOA which is issued to the private respondent, which was not with us. So we brought an IA saying that this is what has brought, and we sought for amendment of the writ petition. In the meantime,
LOA or work order?
the work order which was issued. Now, my lord, the learned single judge heard the matter on the basis of modification variation of the order. And ultimately, 14th of January 2025, that order was stayed by the learned single judge, which they sought for modification variation order. Against that, they went for an appeal against the order before division bench. Their whole contention before division bench was that, look here, there is suppression of material fact. One. Secondly, the amendment was not allowed. It was at the stage of not allowing, then where they made a prayer of 14/1/2025. How this order could have been passed. So the learned division then heard the matter, and both the order was vacated and said that you go for learned single judge, and that will be subject to final order of this court. That was the position. Now, subsequent to that, in the earlier, before coming to the court, we filed a representation before the authority. And we have written the representation. We have suspicion regarding the financial bid. Techno-commercial bid, he is not qualified. That's our whole case. That is one case which we have made out prima facie. Now, subsequent, we came to know that financial bid, which was given by the private respondent to the ONC authority, we came to know that we have made a representation. There was some doubt in our mind. We did not have that proof on that. When you file minor, two things they want, financial bid. One is positive network and one is turnover. This is very important. There is under the qualification, under the criteria, technical criteria, clause 6, that criteria is there. So you have to qualify that criteria. Now, we doubted because you can see all this in uploaded nowadays. We have seen that income tax returns, where the CA, normally the returns are there, fine. We have seen that the year for 2022-23, here said the net worth is 25 lakhs. But in the positive net worth, the certificate has to be given by CA, we have seen the 73 lakhs. So we have doubt, but we didn't have any proof. At the relevant time, fine. Subsequently, we made an RTI we made a complaint to the Institute of Chartered Accountants. Look here, this is what the particular subject, and this is the CA, whether CA has given this certificate or not. Now now a reply has come from the CA also, because complaint once we file that this is what has happened. Now they have given a reply saying that chartered accountant has said that this is not my signature. Where the positive network, that is not my signature because when I upload it is always digital. Secondly, 25 lakhs which has been reflected in the returns, income tax return, that is correct. That may be 25 lakhs. But positive network, that is the chart which is given, the 2073, is that is not the chart I have given. From where the chart has come out. So this way, my lord, an ODIN number is now mandatory, which was not there. So this is what we projected now before this on reports. Now today, now balance sheet also there is, this is also a problem balance sheet. He denied, this is not. Now, my lord, today is a date which are moving it. At least that we should get the information.
Have you submitted any representation to the authorities with regard to what they are saying just now?
No, this is because this is what we have come up. We have
Oh.
already said, no.
Should go to for
No,
them
no,
first.
no.
How can you
No,
come directly?
before that, we have complained. Before that, we complained.
Where,
There is a doubt.
where is the complaint
No, this complaint is there.
regarding the issue that you have just
Yes.
brought out?
Page 181 kindly this. My lord, 181. With concern because submit a bogus document. Got it, my lord. May I?
Yes.
So with reference to my previous 10/10/2024 regarding submission of dubious document by bidder, namely South Asia Consult, Unique Consult Technology, I request your authority to take necessary step to protect the integrity of tender process. But now, after the second clarification we have sought from few of the bidders, it has been observed that once again the bidder Unique Consult Technology has submitted documents such as undertaking so and so and tedious statement declaring false facts and figures. In the undertaking, bidder Unique Consult has made an effort to defend so and so. Now, if your lordship goes to kindly take second paragraph. Similar request going to seek similar paragraph for bidder South Asia Consult as they also submitted similar bogus document from the first round of so and so. Sought from all the bidders we will see tender number so and so. Page 187 kindly see 187.
Yes.
Yes. Now, kindly see fraudulent acquisition. South Asia Consult, while submitting a positive network certificate with a turnover of 73% duly certified, chartered accountant with a UDIN appears to have fraudulently obtained a UDIN registration certificate by submitting manipulating financial data as it exceeds the threshold limit of so and so, which is for clarification of the small enterprise under so and so. Description suggests that the message South Asia submit a separate set of financial document to so and so portal likely with a lower turnover to qualify as so and so available so and so.
No, where is the, you see, this is of 17/1/25.
Yes.
Now the chartered accountant's letter is of which date?
Chartered account subsequent, man.
Right.
Subsequent is this, my your lordship will see from a page. It starts from 296 and chartered accountant letter 310.
Ninth April.
Yes. This is not. 19 April we have received. We received 19 April.
So what does it say?
With according to the provision of Rule 8 for Chartered Account Procedural Investigation, Professional Order Misconduct Conduct Cases Rule 2007, we are sending her with a copy of written statement dated submitted by CA. So and so, copy of this rule is enclosed. We are requesting send a rejoinder if any. Now, next place 311 is reply by CA. Kindly see at 312. 312. This is the first allegation. The discriminant certificate issued on 2nd of July 2024. Turnover mentioned in 3CD, that is the income tax certificate issued on 2nd July turnover and network figures while routine is for positive network. It responds to the above point. I like to clarify the following matter. A, certificate issued on 2nd of July is for positive network, and I did not mention any figure in the certificate. Copy of the certificate is enclosed. Your lordship receives for a moment quick Roman 299. Kindly see 299. 299. Keep in one hand 299. See, this is the, while submitting this bid, my lord, these figures were not there. Lordship got it, my lord. This is a handwritten.
No, what I'm
I have understood.
getting at.
No, I have understood what your lordship is saying. That this complaint, whatever you have now submitted before the court, before coming to the court, have you made a complaint? That's what you're asking.
Correct. Because you see, the authority to decide a tender, the bids is that authority. And a lot of power has been given to them to decide the issue. Now, if they don't decide, then you can come here, but you have to bring it to their notice that this has happened.
Why, my lord? I'll give a quick reply to it. Your lordship's query. Normally, when this type of a complaint is made, you have to approach the authority, then come to the court.
Yeah.
But this is normally, now this is a case where already a writ petition was filed earlier. In respect, my lord, kindly bear for a moment. I have understood your lordship. I am agreeable with you. What I am saying, today I am not asking for that lordship will protect us. It's not that. What I am asking, then let them take instruction whether it is correct or not. If it is not correct, end of the matter. I don't have a case, your lordship will throw me out. If it is correct, my lord, what I am saying, if it is correct, then definitely your lordship will look into it. Today, what makes, again,
No, you see, the other thing is,
after 1 month, they doesn't decide. I come to the court, it becomes too late for a day because already writ petition was filed. I didn't want trouble with another writ petition. Let me withdraw it, refile it, bringing notice to the court. But it is nothing that, my lord, they are the authority. They know whether this particular, my lord,
it is only when you don't have any other efficacious remedy left that you should come to a writ court. Writ court is not a court of the first instance. It is a court of the last instance.
that's right.
You cannot use
My lord,
a writ
already
court
is-
to pressurize somebody else.
I-
Now, if you can bring to the notice of this court that this information is with them and they have not acted upon it,
This
that's okay.
information-
But you cannot say, we are bringing this information to the court. Now you take it up on our behalf on them. That we are not a post office for you.
I'm not saying that your lordship will act as a
No,
post
no,
office, whatever we say. If your lordship is not
You-
willing, that's a different thing, my lord.
No, I'm not willing because you see, this is
not
a,
willing, that's a
because
different.
this is, you have to bring it to the authorities first. They are the ones who are going to decide. If you show them this is what has happened, whatever you have brought it here, and then they do not decide the issue, you give them a time limit. You yourself give them a time limit. Please decide within this many days. And if they don't agree, then you can come. But at the first instance, I don't think you should come.
Because why I came before this court, my answer is that already there was a petition pertaining to same contract. That's the reason I have come, my lord. I am also aware, my lord. I thought that first petition was filed. Regarding about the same contract, I took permission from the court. Subsequent event has taken place in respect to the same contract. It's not that something is a new contract.
Maybe, but then it is a subsequent event.
No,
like
no,
this.
subsequent event, my lord, the court can look into subsequent event.
No,
No, court can. I can
it
look
can,
into-
no, it can, but the proper thing is that
But
it-
suppose I would not have filed it for, let us say, this way I argue. Suppose I didn't file any writ petition, I come with an application for amendment saying these are events has taken place. Then your lordship would say that yes, let us.
you see, if it was during the proceedings, during the sub judice of a case, proceedings occur, new facts have come out, then it's okay. But in this case, it has happened while now this case is a new case.
No,
It may have happened earlier. Now that case has been withdrawn with liberty to file a that is finished, a closed chapter.
no, that time,
You can bring out those facts again, but then the subsequent events for which you have filed this case is different. Now, this issue of the chartered accountant saying that I have not written this, I have not done this, was not an issue there. It was only a suspicion. Your suspicion has been proven true. Now, Now, if a suspicion has been proven true now, then you tell the authorities, the author who makes the tender. This is what has come to light. Now, please use your common sense as to whether they should still be allowed to continue with the contract.
But this is a event which is connected with the earlier repetition. It's a connected matter.
Maybe.
It is a connect, no, my lord, it's a connected with the earlier repetition.
Yes,
Subsequent
yes,
events in respect of the same contract,
But
which
it's,
is not a different contract.
but your entire case is now basically this.
No, entire case of twofold. No, my entire case is twofold.
Hmm.
Not this. My entire case of twofold. Techno-commercial bid, they are not qualified. This is also, this is a prayer I made, coupled with the financial bid. It's not that only I am confined to a subsequent. My whole case also, why I brought it, my lord, is only to bring it that again amendment, again I have to correct it. Those are things are there. My lord, my prayer of the repetition techno-commercial bid, along with this always remains. Now the amendment was allowed. That, my lord, has not changed. Techno-commercial bid, today also it remains. He doesn't qualify technically also he doesn't qualify. He submitted, my lord, he submitted document after closure on 1/8/2024. On 8/10/2024, he submitted the document, which is totally a new document he has submitted, showing his experience. Showing his experience, man. Manpower, he has shown that manpower. Now the authority has said, no. What you do, not for a clarification. My lord, this is only, there is a provision on the clause 5 of the NIT.
Okay, let me hear the other side. There's hardly any time now.
My lord will kindly come to page 200. This is the work order.
January, but
14th of January 2025. This work order was suppressed in the earlier round. That is what we pointed out before the learned single judge. Stay was not vacated. We went up in appeal. The Honorable Division Bench found that it was only, not only was it suppressed, a submission was made that the work order has not been issued. That was noticed by the Division Bench, and Division Bench vacated both these interim orders. It is of 14th of January. Now your lordship will kindly come to the documents that have been placed. This is the very foundation, page 310 that was placed by my learned friend. Work order issued, contract executed. Now on 9th of April, they get hold of some document. No copy, ONGC is nowhere connected with this document. They are having some personnel issue with the Institute of Chartered Accountants. How are we even privy to it? We are not even aware. For the first time in the repetition, we come to know that there is something going on. They are asking about the credential. Financial
You're for who? You're for?
ONGC. Therefore, it has rightly fallen from your lordship that unless it is brought to our notice by way of a representative, and that is the whole foundation for moving a repetition, that you have approached the authorities and the authorities have denied your rights. Only then your lordships entertain a repetition. Where is the scope for entertaining this repetition at this stage? This is something entirely new. And assuming 9th of April, something has happened. Now there is already a concluded contract. We cannot turn the clock back to January. We have to terminate the contract. It is a completely separate consequence that will follow, assuming all this is correct. But unless it is brought to our notice, where is the scope for us to even getting an opportunity of examining? And there are various other issues on the merits. It's a very voluminous petition. Just to show your lordship will kindly come to there for representation. Originally that was submitted. Petitioner submits a representation at page 180. 180.
Yes.
181 that was read out. This is not even a selected tenderer. 180 is the original representation that was submitted in respect of the private respondent.
No,
And
187 also there.
That is later, my lord.
Yes,
But the original objection with regard to the qualification of the private respondent is this. And your lordship will kindly peruse the first paragraph. We sincerely express our satisfaction and appreciate ONGC for its dedication to maintaining transparency in the tendering process, particularly through the CPPP platform. These initiatives greatly contribute to a fair process of allowing bidders to review the credentials of their competitors, thereby ensuring an equitable environment. They're admitting that we have done a very transparent thing. However, upon reviewing the documents submitted for the current tender, we have identified serious discrepancies in the submissions of two bidders, South Asia Consultancy and Unique Construction, etc. Now, with regard to South Asia, that is the private respondent. This bidder has submitted an experience certificate claiming operational work in the Halisa oil field from March 1, 21 to February 28, 23. However, according to data available on the DGS website, the validity of this field expired on January 29, 2018, with no subsequent renewal information. Therefore, it is clear that South Asia Consultancy could not have conducted any operational activities in this field beyond its expiration date. The submitted documents appear to be fabricated, and we request a thorough investigation to verify the legitimacy of their claimed experience. We examined this. We found that there is no truth in this because this Halisa field was extended for 20 years more. And when we file the IA, if your lordship will kindly come to the IA at page 210.
No, why going to that?
The reason is this, madam. This is a complaint he had lodged. He had submitted a representation. Since it was during the course of the tender process, we examined it and we disposed of the representative. Now, here is a 9th of April document. We are not even aware. And straight away they are approaching this honorable court. Why would your lordships even entertain this kind of a petition? What I wanted to point out to your lordship is this one. When we filed the IA at page 210, that has been annexed. The IA has been annexed. This Halisa field business is a annexure to this IA. They do not, they only, if your lordship will kindly come, again they resort to the same kind of separation. If your lordship kindly comes to page 229, sorry, 231,
yes.
This is the affidavit to the IA. Your lordship will find that the annexures are conspicuously missing. And this, that is the main, in the other writ petition that was withdrawn, this was the issue. And they now suppress this document. Now they come up with an entirely new case saying that this is what we have found. Unless it is brought to our notice, where is the question, scope for even examining it? So therefore, in my respectful submission, your lordship will dismiss this writ petition, grant them the liberty to approach us. We will examine the issue, and if it is found to be correct, consequences will follow. Now, this cannot be a ground for setting aside the tender because this is a subsequent tender. At best, it will entail a termination of the contract. So all these aspects are there. So therefore, my respectful submission at this stage, without going further into the merits of the case, at this stage, your lordship will simply dismiss, giving them the liberty to approach us. We will take a call.
But Halisa was not the ground in that particular petition.
Anyway,
Halisa was not the ground. My learned friend said, Halisa is not a ground.
Anyway, with regard to the new ground that you have got, why don't you submit a petition? If they do not take a decision within a time period, you come to this court. We will see.
They will take 20 days, 25 days, 1 month, they will take.
No, then you give them time. You say that within, if you don't take a decision within 2 weeks, or within 2 weeks, then we will be constrained to come to this court. You come.
We'll give you 1 week time, then we'll approach them 1 week. Within 1 week, they will dispose of the petition.
No, we'll give them at least 2 weeks time.
No, your lordship will kindly see.
1 week.
This is an issue. If your lordship will kindly come to the document, we have no connection with this. Whoever this Institute of Chartered Accountants is, this is a private communication happening between the petitioner and the Institute of Chartered Accountants. We have to verify with the Institute of Chartered Accountants. At least 3 weeks will be required.
My lord, 3 weeks intimate. That's the reason, my lord, they will go ahead.
They will go.
My lord,
Already,
no,
work order issued in January. Now we are in May.
No, maybe.
Exactly.
Maybe you have gone. But that is why I know, my lord, they will drag this particular issue. I know.
No. So you
Well, you're watching the direction to them. Direction. We'll file it tomorrow itself.
We'll give a liberty. We'll give liberty to him and let him submit his grounds and take a decision within 3 weeks. He says that he's correct because he has also got to verify from your Institute of Chartered Accountants.
There's verification is there. I'm not saying that.
Whether your documents
what I said to the court, I didn't say initially that your lordship, what I said, that let them verify. Today, what will be difference? Difference will same, they will verify. Now, 3 weeks time is
No,
given.
no, we will tell them to verify and take a decision
No,
on that.
that is why I'm saying.
On,
Correct, your lordship is right.
uh,
So today, why I'm saying, what is the very first thing I said, my lord, there is no place of in any interim order. Because I said that they have to verify first. They can verify on this
no,
petition.
no, not in the way that has been done.
Yeah.
Yeah, you're putting pressure on them. This is not the way it should be done. You cannot use a writ court to put pressure on somebody. Unless they let them take a decision.
Yeah, themselves
Well-
saying we have been very transparent, we'll be transparent.
No, it's okay, fine. I
Ah.
didn't say.
This
I
is-
told them that yes, you take time so that you can verify whether it's correct
No,
or not.
because if we allow you, tomorrow we'll have 20 cases coming like this. Before anything, they'll say that we filed this writ petition, we don't want to stay. Please ask them to verify and take
My
decision.
lord,
I'm not
my
going to
lord,
that.
this is what I don't do it, my lord.
No, no, I'm
Yes,
saying
no, I
that
don't do it.
what I'm saying is if I allow this, if I allow this,
No, I
that
will
is
not.
what's going to happen
I know,
tomorrow.
my lord, that is why I have come up, I told the very first itself. But I am also, I know this, my lord.
So we'll allow you to file a representation to them. You file a representation to them. Within 3 weeks of receipt of the representation, they should take a decision on the said representation. And if they don't take, you come in. Then we'll take steps. We'll see. Because like he rightly said, now it pertains to termination. It pertains to, it's not issue of allotment of the work order or allotment of a contract. That has gone. Now it pertains to termination. Termination cannot be done per se at his own whim.
No, no,
There are
definitely,
certain
my lord.
procedures to
No,
be
no,
followed.
That's why, my lord, when I moved this petition, I have given copy to the private respondent, to all the parties
No, no,
concerned. No, because I
When-
have given them.
Ah.
I have given them to all the parties concerned. Because all the parties were there before the earlier round of litigation. Copy has been served to the private respondent. They should be also aware of it, what I am filing it my. And in clause 40, at page 110, at any stage, see clause 40 of 110.
No time now. I'm rising at 1. I've got a lot of matters. To do. I've got, not because I'm rising to
Okay.
go home, but
No,
I've
it's
got
okay, my
I've got to head a tribunal at 2.
No, there's
So
no
that's going to
trouble.
be a
My lord,
long drawn hearing there.
only what I say that CA admitted himself that there is a fraud. What more, my lord?
So
Let
let
them
them
verify.
clarify. Let them clarify. That is your allegation. Might be correct, might not be correct. Let them take a decision. And let them take a let them take a action on the basis of the decision to be taken. If they find that it requires some action to be taken. So that cannot be done just at the whims.
I am not saying that.
Some time has to be
Okay,
given.
I didn't say, my lord, that you have the decision in today itself.
Yeah.
That's why I said, let them take
But
time.
what they are doing is they are coming to this court at the first instance and thereby not allowing you see, because they have got a Damocles sword hanging over their head with the High Court thing. But that is not the way it should be. They should be allowed to have take their own decision after considering without fear of anything. I mean, you are having a court case. No one likes to have a court case.
We also don't like to have two cases.
No.
I
For
also
lawyers,
don't
no.
like.
Lawyers, I don't know.
It's not that unnecessary, we'll file something bogus litigation.
No,
I
I'm
don't
not
do-
saying that. I'm not saying
I
that.
don't do all this
I'm not
because-
saying that. Only
No,
thing is,
that's
I'm saying that
Lawyers,
procedure.
fine. Okay, we are in this profession, we have to. But my lord, to the best of our ability, when the matter comes, we also examine. It's up to the court.
No,
It's
that's
not a
not.
bogus litigation.
No,
to come.
I'm,
At
no,
my stage,
no one
my
is
stage
saying,
I'll not do.
no one is saying it's
No,
bogus.
but my stage, I will not do it.
Okay.
That I'm saying.
So do I dispose it off that way that they decide or? Huh?
Your lordship will pass.
Yeah.
I'm not putting
Okay.
a consent, your lordship will pass this.
No, I just wanted to know because my words will be different.
No, by consent, it is not. Your lordship
Okay,
will pass it.
then it's a bit different.
Then
That's all.
disposed of with a direction that your lordship will say that.
Okay. Right. Heard Mr. Didas, learned senior counsel for the petitioner, assisted by Mr. Ash Sharma. The also heard Mr. I. Chaudhary, learned senior counsel for the ONGC.
1 to 4.
1 to 4. Assisted by Mr. S. Chakrabarti. Mr. U.S. Bora appears for respondent number 5. You have a private respondent. Okay, right. The petitioner has approached this court after withdrawing the earlier writ petition with Liberty, that is WPC number 715 of 2025. With Liberty being given to file afresh, while order dated. What is the order dated?
2025.
Huh?
8/8/2025. 8/8/2025.
8/8?
No, sorry,
Cannot be
8/5.
8/5/2025. 8/5 cannot be 8/5. Last week,
Yeah, yes.
8/5, last week. 8/5/2025. Full stop. The petitioner had initially filed WPC so and so, with respect to the tender, with respect to the NIT dated 6/6/2024 for hiring of scrapping winch for Assam and Ahmedabad assets under the ONGC. The petitioner's tender with regard to the above NIT was with regard to the Assam assets, ASSETS, assets. The petitioner had put to challenge the impugned list dated 3/1/25 issued by the ONGC, notifying the technically qualified bidders, including the respondent number 5, on the ground that the respondent number 5 could not have been, was not technically qualified. Full stop. The petitioner has now approached this court on the ground that the documents submitted by the petitioner thank God at least the cricket score only. What have I said? What have I said? That the documents submitted by the petitioner, which had supposedly been certified by a chartered accountant, were fabricated documents. In this regard, he has relied upon the letter dated 9/4/2025 issued by the Institute of Chartered Accountants of India, bracket pay annexure 338. This is 38. 38 bracket Kohli, which purportedly, which states that the certificate that had been submitted by the which purportedly states that the certificate issued by submitted by the respondent number 5 along with his bid document was fabricated. So this 38 Kohli is the only document, correct? Right. Next. The petitioner's
And
counsel
also the
submit.
consolidated financial statement, consolidated financial statement.
Where is that?
That your lordship will find. 312, 312.
There only, it comes under
312.
38 code, it comes under that.
The 30th, entire 30th.
Ah. Okay, first up, further, the audited financial statement of the respondent number 5 also was also fabricated. First up. Next part, next. The petitioner's counsel submits that the said documents that had the submits that the said letter dated 9/4/2025 issued by the Institute of Chartered Accountants of India, along with its enclosures, which are annexed as Annexure 38 colli. Clearly showed that the financial bid of the respondent number 5 could not have been accepted by the respondent authorities. So, sir, they accordingly submits that the work order issued to the respondent number 5 in the month of January 2025, forget that, in the month of, issued to the respondent number 5 has to be set, has to be terminated. Yes, sir. Next paragraph. Mr. I. Chaudhary, learned senior counsel for the ONGC, submits that the issue raised by the petitioner by way of this writ petition has never been brought to the notice of the ONGC except by way of this writ petition. He submits that if the issue is brought before the notice of the ONGC, the same will be examined.
See,
and
had it been brought to our notice, we could have examined.
examined and a decision taken on the same. First up, next, I have heard the learned counsel for the parties. On hearing the counsel for the parties and perusing Annexure 38 bracket colon, comma. I am of the view that the issue raised by the petitioner should have been brought before the ONGC prior to approaching this court under Article 226 of the Constitution. Comma, in as much as the writ court is a court of the last resort. Is normally the court of the last resort. First up. In view of the fact that the issue has not been brought to the notice of the ONGC earlier, this court is of the view that the petitioner should submit a representation to the ONGC along with by enclosing Annexure 38 colon and thereby giving an opportunity to the ONGC to examine the issue raised by the petitioner and to take a decision as it deems fit and proper. Gustav. I think that's the only 38 colon, that's the only thing.
But my techno-commercial bid, that will be.
That is all.
Actually spelled out.
okay.
Again, to get
when
I come with the repetition.
That is right. The petitioner is accordingly given the liberty to file a representation to the ONGC with regard to the above issue within a period of, which should be done within a period of,
Say 3 weeks.
no, your representation,
My representation. By 2 days?
no, within a period of 2 days
Yes,
from today.
yes.
Full stop. Thereafter, the ONGC should examine the issue raised by the petitioner and take a decision thereon by way of a speaking order within a period of 3 weeks from the date of receipt of the representation, along with a copy of the writ petition. Full stop. The issue of whether the respondent number five's technical bid should have been rejected. What do you call it?
Commercial.
Techno commercial bid should be rejected. No, just say no prejudice. The there'll be no prejudice. Huh? I'll correct that. Whatever. The writ petitions accordingly. Huh?
The other issues which are
okay.
will remain open. So
Yes,
far.
yes. Okay, the other issues raised in the writ petition shall remain open.
Yes.
The writ petitions accordingly disposed. Basically, this is the main issue now.
Yes, yes. Well, no, that is also.
I know that is also an
That
issue,
is
but
also issue. That is an issue. Deputy office. Can this matter be taken up next Wednesday?
next Wednesday, why next Wednesday? Okay, not next Wednesday.
Next week.
On the prayer of the parties, list the matter on
21st.
21st.
Wednesday.
Is it lengthy matter?
Too lengthy.
Lengthy.
Too lengthy.
Lengthy then on a hearing day is required, not on a Wednesday. Wednesday is the motion day.
Hearing.
The week after that, 24th. 24th. Not 24th is Friday.
24th is.
24th Saturday. No, you can make it on 27.
Yes.
27.
Deeply.
Yes.
Last week on it, right, to obtain. Well, they have fought for some time, a lot, got some communication. Maybe after 2 weeks, now they will celebrate. Because of the first side and all, well, the election.
Same thing, the next page also, next case also.
There is.
Okay, right. Mr. B. Roy prays for adjournment on the basis of the chief engineer's letter dated 13/5/2025. Praise the Lord. This is the matter after 2 weeks.
After 2 weeks, well, yes. I pay for a date, my lord. That will be on 27,
No, next month.
then my lord, out of.
No hurry, Mr. Council, just wait. This matter pertains to your contract matter of which year?
My lord, 2021.
21.
Bill has not been paid. Part of that bill.
Why don't you file a civil suit for
My lord,
damages?
it's a admitted amount, my lord.
Admitted, let us see if it's admitted. What about the next item? 16?
What of that? We have also instruction evident, we have communicated that. We are still after 2 weeks. my lord.
No parawise comments?
No, not yet.
Same, 2 weeks, huh? Next.
Maybe a date may be fixed after.
What is your case here? What is your case?
This is, your lordship, the GMC has to demolish that.
Why? Why? What is it? What is your interest?
I am the occupant of, I have the flat in that building.
Huh? You have a flat?
And here I want to submit to your lordship, the James. The respondent number 3 has filed a petition for regulation of the unauthorized construction. So under the court instruction, the GMC has conducted 2 meetings with the on 3rd and 5th of May. And the decision must have been passed to the Rana Court. The instruction from the GMC must have come by this time, I think.
Who is for the
speech
GMC?
is not here. And these are the letters the meeting was held in the, and both the party attended the hearing.
So, no, we are awaiting the decision of the GMC. Okay, we'll wait for the GMC. We'll get back to it. Just right, heard the counsel for the petition, heard the petitioner who submits that a meeting has been held by the GMC with regard to the issue raised by the petition. However,
Regarding the appeal filed by the respondent number 10 for regularization of his unauthorized construction, that was filed.
I know regarding the issue raised.
I'm for respondent number 3.
What has happened? GMC, yeah, for the GMC.
No, private.
Private respondent.
What is the decision taken by the GMC?
Lordship, that will, the CMC will provide to Lordship. Lordship, we are going to file a reply affidavit loss.
Reply affidavit, I don't want reply from you. I want only a counter affidavit from you.
Lordship, we sought some time, Lordship.
Huh?
We sought some time, Lordship.
How much time?
2 weeks time, Lordship.
Mr.
Essay Bhatia.
S. A. Bhatia.
Bhatia for NLM.
Learned counsel for the respondent number 3.
3,
Submits that he will file affidavit in a position within
2 weeks.
2 weeks. Right, next. Mr. The counsel for the GMC shall also obtain instructions as to whether the meeting minutes held on
Third and fifth May.
3rd and 5th May 2025 has been issued by the GMC. This is the matter after 2 weeks.
Your Lordship, please give me a specific date.
Huh?
A specific date would be better.
Give it it. In June.
22, the May.
Yes.
After 10th of June, Lordship.
Okay, after 10th of June.
Lordship, I need to file an affidavit of reply.
You see, your item 18 is infructuous. There's no point keeping it pending.
No, Lordship, I just need it for one particular point. I have my contention. There is a show cause itself was barred by limitation.
Madam, that show cause is barred by limitation. That is not an issue anymore.
No, I
You see, if the show cause was an issue, then 19 and 20 takes care of everything. It is subsumed into that.
Fine, Lordship, I said, Lordship, 19 and 20, Lordship, 2 weeks time.
Yes, 19 and 20 will keep it, 18 will dispose of.
Lordship, close it.
Yes.
In 19 and 20, I'm led by senior counsel, my lord, and in 18, my lord, I'm appearing for ONGC.
Okay, 18 will dispose of, because 18 is,
Lordship, we close it.
yes, okay, right. Heard Miss, M. Hazarika, senior counsel for the petitioner. Assisted by Miss
That's the one.
S. Dewar. Huh? Dewar. Also heard Mr.
Yes, Chakravarti for ONGC and all.
ONGC. And Mr. I. Chaudhary for?
For ONGC, 19 and 20.
Okay, yeah, so you're not here for this. Huh? On the prayer, in view of the
Termination order dated 13/3,
in view of the termination order dated
13/3/25,
13/3/2025,
followed by order of provisional blacklisting dated 19/3/2025.
and the order of provisional blacklisting dated
19/3/25.
19/3/25, the present writ petition has become infructuous. Accordingly, the writ first up, in view of the submission made, no, what have I said? No, before that. Okay. And the petitioner's counsel submits that the present writ petition has become infructuous. Full stop. And the writ petition accordingly closes infructuous as a challenge has been made to the termination order and the so-and-so, by WPC number 1604/2024 and 1659/2025.
2025. by the way.
Okay, 2025, both them.
Both 2025.
19 and 25, yes, what is to be done here?
I need 2 weeks time to file my reply. And Lordship, it may, it's on the 30th of May. It is not inconvenient.
Okay, if it is not inconvenient, can it be on 4th, madam, 4th of June?
I don't know, you all to decide when you all want.
Both of them.
Okay, you want to file the reply in which one?
Both.
Both. Okay, all right. Ms. M. N. Hazarika shall submit that she will file affidavit in reply in both the writ petitions by the end of this month, before the end of this month. This is the matter on 4th. Perfect. Very well.
Better relativity supplement from the market. Lordship, I am for the restaurant number 5, Lordship. Matter will be password for timing, Lordship. Mr. Caprice is on the last day because the matter is response to the because the supplement was made in the name of the restaurant number 5. On that day, I was in position. I was in position, market was settled in my name for 24, 25 matters. And I said.
You see, let us see the High Court order.
It was a page, it became.
Page 50.
Page 50, madam.
Huh?
Annex 5.
Annex 5, page 50, madam.
Page 50.
50, madam. Fifty, 51, madam. Now this order you have also directed to only representations, madam. There is no direction to cancel this settlement made in the name of the petitioner. Again, on the date of cancellation, you are paying the revenue outside, madam.
So on the basis of the on the representation, so this respondent number, the petitioner hearing, who was the respondent number 5 in that petition.
But I will respond, but I will not charge with notice. So I could not appear.
So what was the decision taken?
Hello?
What was the decision taken?
This
That-
operators, no loss of time.
Page 53.
Annexure 6, madam. Annexure 6, madam, page.
Okay, so this is the impugned order.
Yes, inform already.
Impugned order. And so this has been made without hearing you.
Yes.
So we will have to see whether it has been done without hearing you or not.
And then on that day, I had paid revenue to government, you all can see that. See the annexure 440 page. Okay, my page 49, you all have to see.
Yes, who is for the other side? Yeah, for whom?
I'm.
Pinardi, you wanted time for your senior. Who is the senior?
Cable word.
Let us wait. Okay. Look, let us fix some other date. The senior is not in.
Otherwise the.
When do you want? When do you want? When do you want?
After tomorrow.
After tomorrow.
No, Monday.
Monday? Monday. List the matter on Monday, on the prayer of the parties. Yeah.
Lordship may kindly produce last order dated 23rd of April.
Yes.
Madam, I have got the pair of us comment. Will you on Wednesday, let me file it.
Okay.
There are
Mr.
15 works filed.
Huh?
15 works have been executed by the petitioner. Some area can do.
Okay, right.
On Wednesday. we will file.
Mr. B. Gogoi submits that he received parawise comments.
Yes.
And that he will be filing affidavit within,
By Tuesday, I will file the litigation.
okay, within 5 days.
Yes.
List the matter on Wednesday.
21st.
Yes, has it been paid?
My lord, I am appealing for response number 2.
Has it been paid?
I don't know, my lord, I am appealing for response number 2. In my pay, response number 4 has been. In the last order.
Yes, madam. Yes, what have you got to say? Have you paid the amount? Okay, let us see. What does the instruction say? Payment has been made. Yes, have you got this letter? Have you got this 22nd June 2023? Show them, give them a copy, show them a copy. Yes, there's no time now. We listed the last week. This is the matter to receive.
Along with another similar contract, my lord. It was earlier, my lord, was listing to the matter.
No. Nothing. This is not the time for mentioning.
My lord, here, my lord, we have received the, my lord, necessary proposal from the district authorities. Within, my lord, probably one week it will be forwarded to the government for payment. By this financial year, it will be paid. I got a return.
Financial year has just started. What do you mean?
No, my lord, last year could not be there, given a specific instruction. So this time, they will.
Mr. B. Goy, learned counsel for the, for,
Respondents, PWD.
this is a contempt.
I was actually requested to appear, so I am appearing there. For Lordship, you say for the respondents, madam. All
For the respondent submits that. A fresh proposal has been
submitted by the
executive engineer, which has been,
now the chief engineer will forward it to the government.
which is to be forwarded by the chief engineer to the
PWD.
secretariat, PWD secretariat. The secretariat is thereafter to send the same to the finance department for approval of the proposal. Full stop. Mr. B. Gogoi shall submit the letter sent by the chief engineer PWD to the secretariat PWD with regard to the contractual dues to be paid to the petition by the next date. List the matter on, give a date.
It will be after 4 weeks.
Not 4 weeks, no, why 4 weeks? 3 weeks. You bring the letter.
Yes, sir. 1926. Same here, sir. Same.
Yes. So what is that? Is the letter by whom?
This pilot instruction I got from the civil engineer itself, that they are going to fund it. Regarding my land compensation. Land location. So you see the last line.
Silly proposal been sent to the finance department or?
It was not ballot accepted. So this year we will, ballot last line says.
Who will submit? Chief engineer cannot. It has to go to the secretariat.
It will have to vote for the secretariat, but my lord, since my lord earlier it could not be done. A fresh proposal has now come from the district authorities. It will be now voted to the secretariat for.
Right, Mr. B. Gogoi shall on the next day produce the proposal sent by the PWD secretariat to the finance department for approval of the contractual dues payable to the petitioner. Pursuant to the letter dated 8/4/2025 issued by the additional chief engineer bracket planning, PWD roads. Assam. This is the matter, give it after 3 weeks.
27.
9/6.
Complied with? Okay, right. Mr. J. Sharma, learned
J.
counsel
Sharma.
for the petitioner, and Mr. P. Sharma, learned counsel for the AFDC. No, for the, no, but this is a contempt.
Oh, it's a.
Prasanta Purakakoti.
For the respondent,
Yes.
submits that the order dated 31/5/24 passed in WPC 3454 of 2020 has been complied with. In view of the above, the contempt petition stands closed.
28.
Lordship, on last occasion, the Lordship peruses to page number 37. I forgot to point out one important aspect regarding this following of this MEA rate by the army officers and the personnel below officer rank. Now, if I may take your Lordship just to one.
No, yes, what is your submission?
If I may just pass. Lordship, it is as per the MEA. But there are some reductions which are made in that category.
Okay.
He is entitled to 2 servants. There is a deduction for those 2 servants.
Okay, so that has been deducted.
Lordship, that cannot happen because on the last occasion.
It's for
It's not for everybody, the army officers, if I may just place one particular.
This is a review.
Yes,
Can
Your
I go into all those?
Your Lordship, that this particular fact was never placed before Your Lordship, that's why. I just flag marked that particular regarding the servant only. This is from the PCTA. and-
This is not even a pleaded case.
That's for the, army officers, they are following this MEA rates. Regarding the servant, Your Lordship, servant allowance, next page, Your Lordship, I flag marked this handbook on pay and allowances. The existing component, next page, Your Lordship, internal page 176.
Yes.
At the bottom, bottom second last paragraph.
Yes, the existing complement.
The existing complement of 2 full-time local servants to the entitled officers will continue to be made at the same rate, that is 5456 per servant per month till further order. So our army officers are getting this particular servant allowance. And they are not. Now, the basis of this, the grave officers are not getting it. Now, the basis of this, if Your Lordship takes up just one particular page of the rate petition, because I annex that particular order. just
No,
one-
review, no, wait.
That particular genesis of that particular order says
No
that
time. No time today. Some other day. But, yes, the which page in the writ petition?
rate petition, page number 39.
Have you got the writ petition?
Yes.
Mr. R.K.D. Chaudhary?
Not with me, Lordship. 32. Just one page, Your Lordship.
Yes.
That particular order says this particular MEA rates are applicable to Indian Army officers and the personnel below officer rank. So not the officers, they excluded the officers. This was frowned upon by Your Lordship. There is no basis as to leave out the officers of grade and only apply this MEA rate specifically to army officers and the persons below officer rank. Now, if I may take Your Lordship to page number 37 of the.
No.
Your Lordship. The rate for.
We are going, I mean, into the entire writ petition.
One particular, just let me point out one.
Yeah, let's just matter. Let's just matter after 3 weeks.
Some date may take, Your Lordship.
It'll come to me only.
Yes, your lordship. Instructions are awaited in this matter from 10%.
Mr.
AK Ghosh on behalf of Mr. S. Datta.
A.K. Ghosh on behalf of Mr.
S. Datta.
S. Datta is granted 3 weeks time to obtain instruction and file affidavit. This is the matter.
I need some further time to file my affidavit also. Instructions are awaited.
This IA, for this IA, you need instructions.
I striking of the transport department as party response.
You see, Mr. Counsel, you see, you want striking off the respondent number 1.
Actually, respondent number 1 is the transport department. Their obligation is only to fix the rates of higher charge.
Mr. Counsel, the respondent number 1 is the state of Assam, represented by the secretary to the government of Assam Transport Department. So if you strike off the respondent number 1, then the state of Assam goes. So your case will, your writ petition may not be maintainable. You are not making a challenge to a state.
Lordship, on that particular last day, Honorable Court number 2, and where the learned standing counsel for transport department.
You see, you can modify maybe the cost title of respondent number 1. You can say state of Assam, you can ask for state of Assam being represented by some other officer or some other department, if you don't want the transport department. But here you have said state of Assam represented by Commissioner Secretary to the Government of Assam Transport Department. So the state of Assam would have to remain in a writ petition. So you have to make an application for modification or amendment of the cost title. Amendment of the cost title you make, so that it is replaced by someone, by the Home Department or something like that. You know, so you can say that the state of Assam represented by the Principal Secretary of the Government of Assam, Home Department, and then the others can be made 2, 3, and 4.
Lordship.
Otherwise, if you ask for striking out the state government, then what
Also, let them stay, Lordship. Let them be respondent. I may be allowed to withdraw the.
Okay. Okay.
Yes.
Okay. Mr.
P.K. Mishra.
P.K. Mishra, learned counsel for the applicant, prays that he does not wish to press his application and wishes to withdraw the same. The same not being objected by Mr. S.R. Barwa and Miss, your name, M. Rahman, appearing on behalf of this MD Bora for the respondents numbers.
Transport department.
No, you, besides Bora.
And for respondent number 2, 3, and 4, Lordship.
Let's say for all the respondents. The prayer of the petition's applicant's counsel is allowed. The application is accordingly dismissed as withdrawn. Then in the main case, yes, what is the
Main case also instructions everything.
okay, right. Mr. S.R. Barwa and Miss so-and-so, are granted 3 weeks time to obtain instruction and file affidavit.
May I get a date, Lordship?
No. 4 weeks, after 4 weeks, give a date, after 4 weeks.
10:31.
Here, my lord, I'm appearing for 2 to 7, my lord. Instruction is awaited, my lord. I wait for some more time.
Item,
31,
whether the issue is before the division bench.
division bands, my lord.
Huh?
Appeal is pending, my lord.
Appeal pending, okay, right. Ms. Yudas, learned counsel for the respondent submits that the issue is pending before the division bench. In WA number
My lord, here, not
249 of 2018.
418,
249,
249 of 2000.
2018. Accordingly, lists matter after
4 weeks, my lord.
4 weeks. In the meantime, the respondents may file their affidavit. The interim to